Yes, I now call on Mr. Lubin for his speech.
Thank you, Madam Speaker. Madam Speaker, I rise today to give my full and unequivocal support to these two bills, the Constitution Amendment Bill number 10 of 25 and the Criminal Code Amendment Bill number 11 of 2025. I fully adhere to the delivery of the Honourable Attorney General with regards to these two bills, but I deplore the banality with which the Honourable Leader of the Opposition has intervened during the debate, completely out of context. He couldn't understand the purpose of those very two crucial amendments that are being brought to our laws, especially to our Constitution. And this is something that is unbecoming from a leader of the opposition concerning such an important piece of legislation that would bring some clarity to our position as a modern society, as a modern country, whereby, once again, another milestone to restore our dignity, our democracy, and our constitutional values. Madam Speaker, way back in 2017, as rightly pointed out by the Honourable Attorney General, the United Nations Committee Against Torture issued clear and forceful recommendations to Mauritius, way back in 2017, 8 years back, Madam Speaker. But the previous government, unfortunately, they couldn't even solicit debates with regard to what was the recommendation of this committee. What this committee said, Madam Speaker, they urged Mauritius to repeal Section 242 of the Criminal Code, which excuses manslaughter when a spouse is killed upon being caught in adultery. The committee urged Mauritius to repeal Section 7, subsection 2 of the Constitution, which undermines the absolute prohibition of inhuman or degrading punishment by preserving laws from 1964, Madam Speaker. And I quote paragraph 42 of those recommendations. The state party, that is Mauritius, should abrogate Section 242 of its penal code and ensure that the Constitution provides for the absolute prohibition of torture or cruel, inhuman, or degrading treatment. The previous regime failed to address all these issues, Madam Speaker. And today, we've got a government, together with the way that the Honourable Attorney General is handling affairs with regards to those very important amendments that are being brought. Each and every 2-3 weeks, important amendments are being brought to consolidate our Constitution, our democracy, and we are awaiting further major amendments through the establishment of the Constitutional Review Commission, whereby each and every citizen would be able also to give their views on those various legislation, pre-colonial legislation that we need to amend, and also to revamp our Constitution after 57 years, Madam Speaker. So, I would qualify, Madam Speaker, Section 242 as a colonial era excuse for gender-based violence. This is the gist of what the Honourable Leader of Opposition has missed to point out. As a patriot, he could have, as the Leader of the Opposition, have a point of view with regards to Section 242, which talks about gender-based violence, Madam Speaker. Section 242, Madam Speaker, belongs to another era. It allowed men to kill their wives or their wives' lovers and then plead passion. It created a legal shield for violence, particularly violence against women under the narrative of betrayal. But this defense has no place in a modern legal system, Madam Speaker. And I would not repeat what the Honourable Attorney General has said, but I would just for the sake of clarity and for the sake of the record, state the position of our judiciary, the Supreme Court, with regard to those particular sections. Madam Speaker, our courts have already begun shifting away from the logic of Section 242. In recent years, judgments have signaled out that the passion or jealousy can no longer excuse or mitigate violent killing. I would state a few and quote a few case laws, Madam Speaker, for the sake of this August Assembly and for the sake of completeness to know how these things are being treated by our judiciary and what are the narratives that now we have to move on with these new legislations coming in. In the case of State against Taku Dial, Madam Speaker, it's a 2017 Supreme Court judgment case. The court accepted the manslaughter plea after a man killed his wife over suspected infidelity. But significantly, the court weighed not only emotion, but also the calculated and prolonged nature of the act, hinting at the limits of provocation. And again, in a 2018 case of Sigulam, Madam Speaker, the killer claimed rage after witnessing his wife with another man. But the court's reasoning focused on the deliberate disposal of the body and the accused's conduct after the fact. Then, the year after, there has been a shift in the tone and principle being adopted by the Supreme Court in Mauritius. In the case of Prayag Singh Bhushan, Madam Speaker, it's a 2019 case, Supreme Court judgment of 74, the court stated plainly, I quote, "Neither anger nor jealousy reduces the blameworthiness of a crime. In a democratic society, violence is not a means of resolving emotional conflict." This is a shift to what the law itself was stating. And this was reaffirmed in the case of Nelia. It's a 2021 Supreme Court judgment case 282, Madam Speaker, where the court stated again, I quote, "Such violence cannot be further tolerated in our society." And again, in a 2021 case of Vishnu Bangari, and confirmed in the case of Jenisen Ramen, very recently, a 2024 case, Supreme Court judgment, where the judiciary dismissed emotional provocation as a defense, even in the face of remorse or psychological stress. So, the shift is clear, and today in Parliament, all of us are unanimous to salute the actions of government and the Honourable Attorney General to bring these two amendments. But again, this famous Section 7, subsection 2 of our Constitution, it's a constitutional contradiction with regards to the values of a democratic society. I am of the opinion that the legality and the morality of this particular section of our Constitution is untenable. And again, I salute, I congratulate the government and the Honourable Attorney General to bring this amendment. And this protects human dignity, in fact, Madam Speaker. Madam Speaker, the Honourable Attorney General referred to France. Yes, France repealed its crime of passions defense in 1975 by abolishing Article 324 of the Penal Code. And that was followed also by Italy in 1981, repealing its Article 587, which had allowed reduced sentences for adultery-based killings. Other countries also, Madam Speaker, Portugal has done so with abolishing its Article 133 of its Penal Code. Brazil, Madam Speaker, in 1991. The UK, Madam Speaker, under the Coroners and Justice Act 2009, created a new partial defense of loss of control, but explicitly excluded sexual infidelity as a qualifying trigger. New Zealand also, these are Commonwealth countries, Madam Speaker, abolished the provocation defense altogether in 2009. And in Australia, Madam Speaker, every state has now repealed or severely restricted the provocation defense, with South Australia completing the process in 2020. So, better late than never. It should have been done in 2017, 2018, but we are in 2025 with a new government mandated by the people of Mauritius, and we fully support this bill. And Madam Speaker, when we talk about this famous Section 242, we cannot speak of that section without acknowledging that it has overwhelmingly shielded men who kill women. Again, vividly described by the Honorable Attorney General. It has allowed rage to masquerade as honor and permitted our courts against their better instincts to reduce murder to manslaughter in the name of passion. By repealing Section 242, we say, Madam Speaker, in this very august assembly, a woman's life is not worth less because she is unfaithful. Adultery is not a provocation to violence, and no one has a legal right to kill in the name of wounded pride. This reform, these two amendment bills, Madam Speaker, strengthen our commitment under CEDAW and the SADC Protocol on Gender and Development to eliminate all forms of gender-based violence. Madam Speaker, this bill does not just update our law. It upholds the dignity of every person, aligns our statutes with our Constitution, respects international obligations, and ends the legal fiction that some killings are excusable because they are emotional. It reflects also what our courts have already begun to do with those latest judgments. And today in Parliament, we shall be making history again because we shall choose justice over tradition and dignity over vengeance. I fully support this bill. I thank you all for your kind attention.
Thank you. Honourable Minister of Gender, it's your turn.
Madame la Présidente, merci de me donner la parole ce soir sur ce débat autour, d'une part, les deux amendements qui sont apportés au Criminal Code, notamment les sections 242 et 245, et à celui qui est porté à la Constitution de Maurice avec l'abrogation de la section 7.2 liée à la torture, auquel j'adhère totalement. Depuis 6 mois, ce gouvernement a réussi à placer notre pays à l'aube d'une ère nouvelle. Et je voudrais ici rendre hommage à mon collègue, l'Attorney General, d'être venu aussi rapidement avec ces amendements, tant au niveau de la Constitution de Maurice qu'au niveau du Code pénal, qui, j'en suis certaine, feront date dans l'histoire de la justice mauricienne. Je vais d'abord aborder l'article 242 du Code pénal et ensuite l'amendement proposé à la Constitution. Pendant trop longtemps, Madame la Présidente, l'article 242 du Code pénal a servi à justifier une injustice profonde, légitimement sous le vernis des vieilles traditions, des actes de violence qui ne sont rien d'autre que le reflet d'un déséquilibre entre l'honneur masculin et le droit inaliénable des femmes à la sécurité. Aujourd'hui, les femmes de ce pays vivent un moment historique, car avec l'abrogation de la section 242 du Code pénal, nous tournons résolument la page de toute forme d'injustice envers les femmes. Dans sa logique historique, la section 242 du Code pénal justifie les féminicides en offrant une excuse légale à un mari tuant sa femme en flagrant délit d'adultère, alors que le contraire ne s'applique pas. Or, la loi doit être un rempart inébranlable contre la violence, une voix forte qui met fin à l'impunité et une réponse à celles qui ont trop longtemps été réduites au silence. L'abrogation de la section 242 du Code pénal veut dire que tout cas d'homicide, de blessure et de coups infligés par un mari ou un conjoint en cas d'adultère ne sera plus considéré comme excusable. En effet, servir l'adultère comme une justification ou comme une excuse pour violenter ou tuer une personne n'a plus sa place dans la société dans laquelle nous vivons aujourd'hui. Dans de nombreux cas, nous avons tous été témoins du degré de violence ignoble, voire odieux, utilisé contre les femmes. Des fois, Madame la Présidente, la violence est utilisée rien que sur des soupçons d'infidélité pour commettre des crimes infâmes. Avec l'abrogation de la section 242, nous mettons fin à un système patriarcal de notre société qui a trop duré. L'histoire nous rappelle combien ces conceptions ont été ancrées dans certaines sociétés. William Blackstone, juriste britannique, définissait les femmes comme les chattels de leur mari, des possessions, des biens privés dénués de statut juridique ou d'autonomie. Il y avait the doctrine of irrevocable consent upon marriage, as stated by Sir Matthew Hale, where, in his opinion, a husband does not require consent from his spouse for sexual intercourse, as the latter is an essential part of the marriage. Blackstone shared the same opinion when he developed the unity theory. Cette croyance, Madame la Présidente, a justifié des siècles d'injustice et de violence sous prétexte de droit conjugal. Si cette conception archaïque a été renversée en 1980 aux États-Unis par une décision de la Cour suprême dans l'affaire Trammell contre the United States, affirmant enfin que les femmes sont des entités juridiques indépendantes, nous devons toutefois regretter que la criminalisation du viol conjugal demeure encore aujourd'hui en suspens dans tant de pays, y compris le nôtre, chez nous. Il est inadmissible qu'une femme puisse être contrainte sous prétexte du mariage, que l'union légale puisse être invoquée pour priver une personne de son consentement et de son intégrité. Nous avons le devoir absolu de mettre fin à cette ambiguïté juridique et de reconnaître que toute forme de violence, y compris dans le cadre du mariage, doit être sanctionnée sans exception. Marital rape, Madam Speaker, is an issue that has to be dealt with at a later stage, probably in the domestic abuse bill currently under preparation. Mauritius, too, will have to mark the death sentence of the marital rape exception. And I am happy that the Attorney General announces a sexual offences bill which will be presented in Parliament. This bill will encompass, I'm sure, sexual abuse on women and minors altogether. Madame la Présidente, la démarche de ce gouvernement n'est pas un acte isolé, mais une pierre angulaire d'une politique globale visant à rétablir l'égalité réelle et à offrir à chaque être humain, et surtout aux femmes, la protection qu'elles méritent. Mais cette réforme, aussi fondamentale soit-elle, ne suffit pas à elle seule à transformer les mentalités qui trop souvent continuent de perpétuer la domination masculine dans notre société. Cette avancée législative s'inscrit dans la logique de nos engagements internationaux et régionaux. La Convention sur l'élimination de toutes les formes de discrimination à l'égard des femmes, CEDAW, nous exhorte depuis longtemps à supprimer ces justifications archaïques qui ne sont rien de moins qu'un affront à l'égalité et aux droits fondamentaux des femmes. Nous sommes aussi signataires du Maputo Protocol de 1995, qui lui aussi exhorte les États membres à adopter les mesures nécessaires pour prévenir et éradiquer la violence à l'égard des femmes. Nous devons donc d'éliminer toutes les formes de discrimination à l'encontre des femmes. Grâce à ce gouvernement, nous sommes donc entrés dans la modernité au même titre que des pays tels que l'Australie, le Canada et le Royaume-Uni, qui eux aussi ont amendé leurs lois pour rendre justice aux femmes. Avec la présentation de ces amendements, désormais, un mari ou conjoint qui tue sa femme ou sa conjointe va devoir répondre de ses actes devant la justice. Madame la Présidente, nous portons aujourd'hui une responsabilité immense, celle de ne pas céder aux demi-mesures, ni nous satisfaire de simples ajustements. Nous répondons aujourd'hui à cet appel avec détermination et avec des amendements qui reflètent notre volonté de progresser vers une justice véritablement équitable. Nous devons aller plus loin, réformer, éduquer et garantir que chaque citoyenne et chaque citoyen de ce pays puisse jouir de la pleine protection de la loi, indépendamment de son genre, de son statut ou de son histoire. La confiance de la population nous impose une exigence absolue d'action. Avec les amendements que nous propose l'Attorney General et l'arrivée bientôt du Domestic Abuse Bill, fini le temps où certains identifiaient leurs épouses comme leur possession, leur bien, leur propriété, plutôt que comme des êtres humains indépendants. Madame la Présidente, dans cette même lignée, l'abrogation de la section 7.2 de la Constitution était nécessaire parce que Maurice a ratifié les 7 traités fondamentaux des droits humains des Nations Unies et 5 optional protocoles liés à ces traités, y compris la Convention contre la torture. En supprimant l'article 7.2 de notre Constitution, cette action redéfinit clairement notre espace juridique. Elle proclame que toute loi autorisant des peines susceptibles d'impliquer torture ou traitement inhumain est incompatible avec nos valeurs fondamentales. Concrètement, ce changement renforce la protection des droits fondamentaux et crée un rempart juridique contre toute pratique contraire aux droits humains. Plus jamais un individu ne pourra voir sa dignité bafouée sous prétexte de sécurité ou de répression, même dans les cas les plus graves. Ce changement améliore le contrôle et la responsabilité de nos institutions. En effet, Madame la Présidente, même si la création de la Commission indépendante des plaintes contre la police a été saluée par les experts des Nations Unies, il est à constater cependant que les enquêtes diligentées par cette instance montrent que trop souvent, les plaintes relatives à ces violences ne débouchent pas sur une action judiciaire ferme, laissant les victimes livrées à leur désarroi. Ce problème est tout aussi grave lorsqu'il s'agit de cas de trafic humain, dénoncés par des ONG et touchant principalement des femmes et des enfants vulnérables. Ces situations alarmantes soulignent la nécessité cruciale d'un cadre juridique qui garantisse en toutes circonstances que la dignité humaine ne soit jamais compromise. En imposant une norme constitutionnelle claire face à la torture et en redéfinissant la section 245 du Code pénal, nous dotons les organes de contrôle et les enquêtes indépendantes, telles que l'IPCC, d'un cadre juridique solide pour agir efficacement contre les abus. Cela permettra de restaurer la confiance des citoyens mauriciens dans notre système judiciaire et de positionner Maurice à la pointe des standards internationaux. Au niveau régional et international, notre engagement fera de Maurice un exemple en matière de respect des droits humains. Le ministère de l'égalité des genres et du bien-être familial travaille chaque jour pour protéger les plus vulnérables et garantir que la justice ne serve jamais de prétexte à des abus. En adoptant ces réformes, nous faisons le choix déterminant d'une législation qui, même en cas de détention, place le respect des droits de chacun au-dessus de toute considération. On ne peut pas tuer la vérité, Madame la Présidente. On ne peut pas tuer la justice. On ne peut pas tuer ce pourquoi nous nous battons. En nous engageant pour ces amendements, nous affirmons notre combat pour la justice, la dignité et le respect de chaque citoyenne et citoyen et l'opportunité historique de corriger des dérives. Je vous remercie.
Merci. Merci, Madame la Ministre.
Madame Speaker,
DPM.
Madame Speaker, je tiens à commencer un court discours en cette occasion, mais je tiens à commencer ce discours en criant, pas en disant, mais en criant mon indignation. À un moment où nous amendons la loi suprême du pays, notre Constitution, pour faire des choses admirables. Le leader de l'opposition fait son discours. Ils sont deux assis là-bas dans l'opposition. Deux. Au moment où le leader de l'opposition fait son discours, l'autre n'est même pas présent. Et ce même leader de l'opposition, aussitôt son discours terminé, il nous tourne le dos. Il s'en va. Après avoir dit qu'il n'est pas en faveur du projet de loi, un projet de loi qui nécessite 3/4 pour amender la Constitution. Monsieur, ça ne me concerne pas. Il a fini de se faire voir sur la télévision, il s'en va. C'est pourquoi je crie mon indignation. C'est choquant de voir ce qu'il reste comme opposition se comporter de cette façon en une occasion pareille. Ceci dit, je ne serai pas long, puisque l'Attorney General est parmi nous. Bravo, et bravo pour le discours qu'il a prononcé en notre nom à tous. Je ne vais donc pas me répéter. Mais aujourd'hui, c'est quand même le jour où nous amendons notre Constitution pour mettre dans notre Constitution l'absolute prohibition of torture. C'est un grand jour. C'est un jour qui s'est trop fait attendre, mais c'est un grand jour. C'est aussi le jour où, Madame la Présidente, Madame Speaker, c'est aussi le jour où manslaughter committed by any person on his spouse as well as on his partner at the very moment he finds them in the act of adultery will no more be an excusable offense. C'est un grand jour pour ces deux raisons-là. Et je félicite ma collègue, la ministre de la Famille, des droits de la femme, pour le discours qu'elle vient de prononcer. Deux grands moments où tous ceux qui sont ici sont fiers de participer. Et nous savons qu'à l'horizon, l'Attorney General l'a annoncé, nous savons qu'à l'horizon, il se profile un New Sexual Offense and Hate Crimes Bill. Et nous trouverons, le plus tôt possible, nous l'espérons tous, nous trouverons dans ce New Sexual Offenses and Hate Crimes Bill un nouveau délit, le marital rape, qui est, nous devons le reconnaître, qui n'est pas quelque chose d'accepté par tous, parce que les préjugés sont difficiles à vaincre, mais viennent le plus rapidement possible ce jour-là. Et je n'ai pas de doute quant à moi que l'Attorney General que nous avons sera aussi, dans ce texte de loi à venir, apporter une nouvelle définition, parce que la définition de rape, marital rape is one thing, la définition de rape qui est dans notre loi est complètement dépassée. Il faudra, nous le ferons tous ensemble, under the guidance de l'Attorney General, nous aurons une nouvelle définition du rape. Ces jours-ci, comme nous le savons tous, et surtout vous-même, ces jours-ci, parce que tous les jours, il y a des débats dans la presse spécialisée, sur la définition actuelle, ce qui devrait être la définition actuelle du rape. Donc, je dis ces quelques mots pour saluer ma collègue, la ministre de la Famille et des droits de la femme, mais surtout, en ce jour tellement important, en notre nom à tous, pour remercier et féliciter l'Attorney General pour le service immense qu'il rend à son pays en cette occasion. Merci, Madame la Speaker.
Merci. Yes, Honourable Prime Minister.
Madam Speaker, the two bills we are presenting today, one for amending the Constitution and the other one to amend the Criminal Code, aim at removing exceptions to provisions in our legislations which allow torture. The Criminal Code is also amended in respect of an injustice in our law, recording the so-called excusable homicide committed by man on his spouse. I will address the House in the first instance on the amendments relating to Chapter 2 of the Constitution. Madam Speaker, I will not repeat what the Attorney General and the Deputy Prime Minister and the other Minister for Gender has just said so eloquently. These amendments are in line with our government program, which provided for amendments to be made to Chapter 2 of the Constitution to better protect our fundamental rights. As the Attorney General has pointed out, Section 7.1, I want to repeat it because it's important. Section 7.1 provides of our Constitution that no person shall be subjected to torture or to inhuman or degrading punishment or other such treatments. However, the same section, Section 2, Section 7, subsection 2, on protection from human treatment, authorizes the infliction of any description of punishment that was lawful in Mauritius on the 11th of March, 1964. By authorizing such punishment, this section, that is Section 7, subsection 2, opens the door to gross violation of human rights by an oppressive regime bent on defying universal principles regarding physical integrity and dignity. With these amendments we are proposing today, we are aligning our national legislation with the universal principles that enhance fundamental rights and fundamental freedom of individuals as laid down in our Constitution, Chapter 2 of our Constitution. The Constitution Amendment Bill proposes to repeal, therefore, Section 7, subsection 2 of the Constitution completely. It is important to recall that Section 7 appears under the heading Protection from Inhuman Treatment and forms part, as I said, of Chapter 2 of our Constitution. It is entitled Protection of Fundamental Rights and Freedoms of the Individual. Chapter 2, Madam Speaker, is at the heart, the very heart of our democracy. In the government program, we have made clear our intention to strengthen and further extend these fundamental rights. The repeal of Section 7, subsection 2 is one step in the wider process, while Section 7.1 bans torture and other inhuman and degrading treatment. Section 7.2 allows for exceptions to this rule. As the law stands, if that punishment was legal in March 1964, then it cannot be considered unconstitutional, even if it is inhuman. That section was originally inserted as part of a larger set of transitional arrangements around independence. In theory, it was meant to provide continuity in the legal system. In practice, it preserved a dangerous mindset. The idea that some forms of torture could be perpetrated by the state as long as it was allowed in a law of the colonial era, is erroneous. As the Judicial Committee of the Privy Council noted, in a case from the Bahamas, provisions like this, often called special saving clauses, allowed for colonial laws to be repealed and then restated without being subject to constitutional challenge. Madam Speaker, no sensible government today would call for the return of corporal punishment, such as flogging or whipping. But the exception remains on the book, as the Attorney General just pointed out, and its very presence weakens the coherence of our Constitution. Worse, it opens the door for such punishments to be reintroduced by simple bill, as the Attorney General pointed out, and thus bypass the constitutional ban on torture. This is why the United Nations Committee Against Torture has repeatedly asked us to repeal Section 7.2 and to bring our Constitution in line with the absolute and non-derogable nature of the prohibition against torture. The recommendation is clear. No justification may be invoked under any circumstances, be it legal, political, or historical, to permit torture or inhuman punishment. We are in total agreement with the stand of the committee, and we are acting accordingly. Madam Speaker, our Constitution is sacred, any Constitution, but it is a living instrument, not a museum. It must be updated where parts of it no longer serve their purpose, value the values which we hold, and further may require further safeguards. This is the task which the Constitutional Review Commission will examine, hopefully shortly. It will work on the promises of the government, of our government program, such as a new generation of rights for citizens, of nature, electoral reform, and the consolidation of national unity. It will require time, expertise, and consultations. But in the meantime, whatever we can do to repeal an absurdity, such as the one we are tackling today, we will do so straight away. As for the Criminal Code Amendment Bill, it is a direct consequence of the repeal of Section 7.2 of the Constitution. Because it deals with homicide, blows, and the lawful authority, we are ensuring that it remains clearly within the scope of the revised constitutional provision. In other words, no exceptions, no loopholes, no confusion. Force cannot be used by the state at the expense of human dignity. The new Section 245 explicitly allows for the use of force and only under very narrow defined conditions: in defense of persons, of property, in the course of lawful arrest, to suppress a riot, to prevent the commission of a serious crime, and even when such conditions are met, the use of force can only be to such an extent as can be reasonably justified in these circumstances. The message is clear. We cannot and we will not tolerate any form of torture, whether from the police or anyone else. This government will not allow any abuse carried out by certain rogue groups, which we have seen under the previous regime, did such things. The citizens of this country must not and will not accept barbarism. Now, Madam Speaker, to the other amendment of the Criminal Code, the repeal of Section 242. This provision dates back again to our colonial era. It was directly inspired by Article 324 of the old Code Penal. It provides that person who killed their spouse and the spouse's lover upon discovering them in the act of adultery is guilty only of an excusable, in between inverted commas, homicide. In fact, it offers a partial defense to the so-called crime of passion. Article 324 was repealed in France, as was rightly said, in 1975. 50 years ago, it was already recognized that this provision was based on an outdated and sexist assumption. In particular, that a man could as if possess his wife, and that a woman who was unfaithful deserved to die. It is high time we recognize it in Mauritius that this cannot be so. The law is uneven in its application, and it extends the excuse to the male spouse, but not to women, only to the male spouse in similar situations. More fundamentally, it legitimizes violence against women under the cover of emotional reaction. It is true, Madam Speaker, that Section 242 has never been invoked in any known case here. But its presence in our law, as rightly pointed out by the Attorney General, is in itself an affront to the principle of equality. The fact that it remains dormant doesn't make it harmless. If it is not repealed, it could one day be used. I think the Attorney General gave an example of Bahamas, if I'm not mistaken, where an act of deadly violence can be rekindled. And that is a risk we cannot afford. The argument is simple. There is no crime of passion. A crime is a crime. Anger, betrayal, emotional distress, these may explain behavior, but they do not excuse the act of actually killing. A society governed by the rule of law cannot allow emotions to justify the taking of a human life. This principle must be taught to our children and understood by all of us. And it must first be respected by our state and embodied in our laws. Over the past decade, our society has seen an accelerated decay in its moral fabric. The law of the jungle and unabashed greed have prevailed, leading to frustration, despair in the hearts of many. The consequences are there for all of us to see. Cases we've seen, cases of road rage, neighborhood aggression, lynchings even, domestic killings are too frequent. The reflex of violence as an emotional response must be stopped. My government is all too aware of the immensity of the challenge, but we are determined. The repeal of Section 242 also addresses another issue. The continued existence of this section contradicts, in fact, our constitutional commitment to non-discrimination. Sections 3 and Section 16 of our Constitution protects the rights and freedoms of all individuals without distinction. Section 242, by contrast, does the opposite. It allows for the law to excuse the killing of a woman by a man because she was unfaithful to him, but makes no such provision if the roles were reversed and it was the woman who killed the man. I think the Honorable Minister for Gender rightly pointed stress on this. This is not only discriminatory, but also degrading. That is why, in 2017, the Office of the Director of Public Prosecutions described Section 242 as an unjustifiable lenient approach, and rightly pointed out that no one, male or female, owns or possesses his or her spouse or partner. To leave Section 242 in our law is to maintain the idea that violence, in some cases, is understandable or acceptable when it is directed against a woman. That fiction has no place in the law of a republic that claims to treat all its citizens equally. Some may ask, why now? I think the leader of the opposition, it's a misconceived idea. I don't know what he was talking about, in fact. But some may say, why? Why now? If the provision has never been used, why not leave it alone? The answer is what the Attorney General has just said. The law is not about precedents. It is about possibilities. A law that has never been used can still be invoked tomorrow. And if it is against the principle we aspire to uphold of equality before the law, of protection against violence, of non-discrimination, then it should be removed. Madam Speaker, there's two reforms, one constitutional, one legislative, are part of the same broader commitment to modernize our legal framework, to remove outdated and harmful provisions, and to align our laws with both our international obligations and our democratic values. The past has shaped us, but it does not define our future. Let us ensure that the laws of this country reflect not the outmoded mores and prejudices of a distant era, but the convictions of our own time. With these words, I commend both bills to the House.
Yes. your winding up speech, Attorney General.
I like the term, Madam Speaker, winding up. I would have thought winding down. But when you will hear what I have to say, maybe you would have said that the expression winding up is a proper expression. Let me first start by addressing the Minister for Gender, my colleague, and say in no uncertain terms, marital rape will become an offence in the next law. And let me address what the Deputy Prime Minister said. Yes, we will look at a new definition of rape in order to ensure due protection of our citizens in this country. We shall not shy away from these fundamental changes, Madam Speaker. It is by promoting a proper structure of our criminal justice system that we will ensure equality before the law, an essential ingredient for the rule of law to prosper. Now, as an answer to the Leader of the Opposition, not for the first time in this legislature, Madam Chairperson, Madam Speaker, we have been served with a half-baked intervention from the Leader of the Opposition. It is not because one is in the opposition that it becomes necessary to say something just for the sake of saying so. We were even served with the very expression I used in my address when I said that on this side of the House we shall leave no stone unturned. And bang, right on time, the same expression was used by the Leader of the Opposition. Then the Leader of the Opposition gave us a brief of what the United Nations had observed as far back as 2017, 2018. What he didn't tell us is that faced with the inactive and downright derelict attitude of the previous regime, of the previous years, we had to come up with a quick but nonetheless substantial amendment to placate the Committee Against Torture in early April when I attended the Geneva Convention. And it worked, Madam Speaker. Next is the inexplicable aberration from the Leader of the Opposition that we should go about things rather cautiously, he said, step by step. And guess what? Exactly the same words I had used in my conclusion. And his next point was rather extraordinary, because he told us that when amending Section 245, we should not create loopholes. When we amend a law and would put stringent conditions on a law, he says we are creating loopholes. How he comes to that conclusion is beyond me. And the final straw was the inability of the Leader of the Opposition to actually grasp the fact that the language of the new Section 245 before this House today, as amended, is an exact replica of Section 4.2 of our Constitution. The A, B, C, and D stems from our Constitution, and he didn't even realize it. And he based his speech on it. I'm tempted to lapse back in French and say, and ask you, Madame Speaker, qui dit mieux, Madame la Présidente? So at this stage, Madam Speaker, I move.
You again commend the bill to the House.
I commend the bill to the House, yes.
Yes. And the motion, of course. The motion needs to be seconded again. Yes, I have many who are seconding the motion. The question is that the Constitution Amendment Bill number 10 of 2025 and the Criminal Code Amendment Bill number 11 of 2025 be read a second time. Those in favour say aye. Those against say no. The ayes have it.
Public Bills Committee stage.
Okay.
Clause 1, short title. Clause 2, Section 7 of Constitution amended.
Question is that clauses 1 to 2 stand part of the bill. Those in favour say aye. Those against say no.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The question is that I do report to the House that the Constitution Amendment Bill number 10 of 2025 and the, no, just that one. This time I do one by one. Therefore, I say it again. Question is that I do report to the House that the Constitution Amendment Bill number 10 of 2025 has passed the committee stage without amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. Yes, you may resume your seats, members. Honourable members, I have to report to the House that the Constitution Amendment Bill number 10 of 2025 has passed the committee stage without amendment.
Public Bills, third reading. I move that the Constitution Amendment Bill number 10 of 2025 be read a third time and passed.
Motion seconded. Yes. You will, therefore, the question is that the Constitution Amendment Bill number 10 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no.
I move that division of votes.
Yes. Honourable members, since there are some of you who are new to the House, I will say a few words. As this bill requires a qualified majority of votes of not less than 3/4 of all of the members of the Assembly, pursuant to Section 47(2)(c) of the Constitution. We will then proceed with the taking of votes by division. The division bell will ring for 2 minutes, and a division shall be taken and recorded by the acting clerk by asking each member separately, in accordance with precedence, beginning with the member who stands last in that order. The vote shall be taken by ayes and noes. A member may also choose to abstain from voting. Acting clerk, please proceed with the division. Ce n'est pas la récréation.
Honorable members, we will proceed with the taking of votes. Dr. Honorable Tanu, absent. Honorable Siben, absent. Honorable Savabadi.
You have to vote.
Aye.
Honorable Somtali.
Aye.
Honorable Rukni.
Aye.
Honorable Ramkilawan.
Aye.
Honorable Ramdas.
Aye.
Honorable Kiran. Dr. Honorable Prayak.
Aye.
Honorable Lucky Ram.
Aye.
Honorable Dobin.
Aye.
Honorable Jagannat.
Aye.
Honorable German. Honorable Henriette Manon.
Aye.
Honorable François.
Aye.
Honorable Edouard.
Aye.
Honorable Edouard.
Aye.
Honorable Doriao.
Aye.
Honorable Colette.
Aye.
Honorable Kazean.
Aye.
Honorable Bijan.
Aye.
Honorable Bichuk.
Aye.
Honorable Babulal.
Aye.
Honorable Babaji.
Aye.
Honorable, Dr. Honorable Omia, absent. Honorable Apollon.
Aye.
Honorable Adrien Duval, absent. Honorable Venkatasamy.
Aye.
Honorable Juman.
Aye.
Honorable Balumudi.
Aye.
Honorable Antil.
Aye.
Honorable Le Govin.
Aye.
Honorable Parapen.
Aye.
Honorable Narsingen.
Aye.
Honorable Baburam.
Aye.
Honorable Aliman.
Aye.
Honorable Pierre.
Aye.
Honorable Fukun Basha.
Aye.
Honorable David.
Aye.
Honorable Johanna Béranger.
Aye.
Honorable Damri.
Aye.
Honorable Lejonga, absent. Honorable Gondia.
Aye.
Honorable Buchit.
Aye.
Honorable Pentia.
Aye.
Dr. Honorable Ramtual.
Aye.
Dr. Honorable Ganga Prasad.
Aye.
Honorable Amia Mia. Dr. Honorable Sukun.
Aye.
Honorable Yuen.
Aye.
Honorable Navar Marie. Honorable Osman Mohamed.
Aye.
Honorable Utim.
Aye.
Honorable Nagalingam.
Aye.
Honorable Ramphul, absent. Honorable Asievaden.
Aye.
Dr. Honorable Chiton, absent. Honorable Soubron.
Aye.
Honorable Richard Duval.
Aye.
Honorable Betchou.
Aye.
Honorable Ganesh.
Aye.
Dr. Honorable Boulel.
Aye.
Honorable Bagwan, absent. Honorable Shakil Mohamed.
Aye.
Honorable Deputy Prime Minister. Yes. Dr. Honorable Prime Minister.
Aye.
Okay. Honourable members, the results of the division are as follows. Ayes 58, noes none, abstentions none, absent 8 members. Honourable members, I wish to inform the House that the Constitution Amendment Bill has on final voting obtained 58 votes. That is, has been supported by a 3/4 majority as required by section 47(2)(c) of the Constitution. I declare that the bill has been read a third time and passed.
Public Bill Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, section 242 of Principal Act repealed. Clause 4, section 245 of Principal Act repealed and replaced.
The question is that clauses 1 to 4 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. The ayes have it. The question is that I do report to the House that the Criminal Code Amendment Bill number 11 of 2025 has passed the committee stage without amendment. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable members, thank you for resuming your seats. Honourable members, I have to report to the House that the Criminal Code Amendment Bill number 11 of 2025 has passed the committee stage without amendment.
Public Bills, third reading.
I move that the Criminal Code Amendment Bill number 11 of 2025 be read a third time and passed.
Yes, motion needs to be seconded. Yes, Honourable Boulel. Question is that the Criminal Code Amendment Bill number 11 of 2025 be read the third time and passed. Those in favour say aye. Aye. Those against say no. The ayes have it. Honourable Prime Minister.
Yes, Madam Speaker, I beg to move for the adjournment of the House to Thursday, the 5th of June of May, 2025 at 5 p.m.
Thursday, the 5th of June at 5 p.m. The question is that the House be adjourned to Thursday, the 5th of June, 2025 at 5 p.m. Those in favour say aye. Those against say no. The ayes have it. The House stands adjourned.